Good morning. I would like to thank you, Yoram. I would like to thank the conference organizer, Rivka, and Professor Rivka Weil, and Dr. Daphne Rishmon-Barak for inviting me. And of course, thank you all for all participants who have arrived. So what's new when it comes to underground warfare? Nothing is new. Nothing is new under the sun. Nothing is new when it comes to tunnel. It's a well-known documented phenomenon. It does undermine, when it comes to digging a tunnel, you undermine the ground, or the solid ground, when you dig a tunnel. You don't undermine the laws of war. They are still solid, but there is a challenge, how to adapt the law to the specific attributes when it comes to, related to, or relevant to when it comes to tunnels. So, when it comes to the ad bellum issues, I would like to talk about the perspective of the self-defendants, but in my military capacity, I would add that precisely I'm not talking about a victim because a tunnel has two edges. It's double edges. It might be used, as the cliche says, when you remember the cliche, that the best defense is an offense. So when it comes to tunnel, the self-defendants may leverage it for its own purposes, and to some extent it might be an opportunity for him from his perspective. Anyway, I would like to talk about the pure self-defense issue relevant to our discussion. So first of all, the starting point for such an adventure is, of course, Article 51 of the Charter. The UN Charter is very precisely, it said, nothing in the Charter will impair the right of self-defense of a member of the United Nations if an armed attack occurs. So we are having two criteria which we shall have to consider. What does it mean, armed attack, and what does it mean, occurs? So let's talk about the mere digging of tunnels. This is not an armed attack. This doesn't justify a war of self-defense. It justifies, it's unlawful, of course. It's a breach of international law. The defendant has its own tools to reply, economic, diplomatic, etc. It cannot start a war due to the fact that your adversary has started to dig tunnels, because there is not an armed attack. By the way, when talking about Article 51, one may mention the fact there are two schools. A strong American and to some extent English school says that the inherent right of self-defense related to the customary law of the pre-charter area is still relevant. So from this perspective, we don't have to adhere to Article 51. But the prevailing view, the common view, and I shall follow it because of the short time given to me, is that Article 51 is conclusive. So if it's conclusive, we have to have two criteria, an armed attack that occurs. So mere digging of tunnels is not an armed attack. No military force is actually used. So you are not allowed to respond by military force. You may respond, of course, against the breach of law by other laws, by other ways, diplomatic and economic, etc. There is a huge body of articles of state responsibility, which is beyond the discussion of today's panel. But when it comes to use military force, and if there is not an armed attack, what are the potentials or what are the venues available for the defendant? So let's start about the criteria of occurs. An adversary digs tunnels. Does the respondent have to wait until the adversary attacks? One may draw from a domestic law. In domestic law, when someone tries to stab you, you don't have to be passive. You may respond. You may be reactive. You may raise your hand. You may fight your adversary. You may counterattack him, as long as he started to stab you or to try to stab you. But you don't have to be a sitting duck. You may protect yourself. So actual digging is not an armed attack. But when it comes to capabilities, intentions, and hard intelligence that your adversary is going to leverage the tunnel in order to attack you immediately, that's a new story. Preventive war is not allowed. Namely, the mere fact that the enemy has capabilities by leveraging its tunnels is not enough to attack it. It doesn't justify war self-defense. So preventive war is not allowed. But when it comes to preemption, here comes a new concept of imminent threat. If there is an imminent threat, a very dominant school in international law says that this justify or might justify your right for self-defense. What does it mean, imminent threat? If the mere digging of tunnels is not an imminent threat, what does it mean, an imminent threat? Capabilities is not enough. Intention per se is not enough. The combination of the two is not enough. There should be another condition. There should be hard intelligence that your adversary is going to exercise his military capability through the tunnels immediately. And one can borrow from Dinstein, Yoram Dinstein's book, I can borrow an example. He reflects or he points at the example of Pearl Harbor. When the Japanese fleet, airplanes, took off from the carriers, heading towards Pearl Harbor, the American Army, Air Force might intercept them. The Japanese already triggered the bullet in terms of armed attack occurs. The attack is on the way. It's heading towards Pearl Harbor. That's already an armed attack. This is a disputed issue. There are some states who adhere to the formal wording of Article 51 requiring actual armed attack. But a very strong school of opinions and of states practice, which is very substantial, leads towards the conclusion that imminent threat may justify self-defense. So, the mere fact that there are tunnels, for example, I can give you an Israeli example, but before giving the Israeli example, I would like to talk about the magnitude of the threat. Usually when we talk about imminent threat and the magnitude effect, we talk about meta-conventional threats, such as nuclear or chemical or biological weapons. The imminency of nuclear weapon is totally different from the imminency of the threat of an infantry platoon that's heading towards your border, or even a brigade of infantry or armored divisions that goes to your borders. When it comes to nuclear threat, magnitude does have its own effect. When we talk about tunnels, this is not a meta-conventional threat, it's a conventional threat. But here, geography matters. And geography is very important. Think about self-defense, think about Germany, South Korea, compare it to Russia. Both Napoleon and Hitler have learned the hard way. What does it mean to attack Russia when you have hundreds of miles of depth? There is a buffer zone. Russia can afford penetration to its force. At the end of the day, it recovers by its counterattack, in its counterattack. So Napoleon reached Moscow, Hitler almost reached Moscow 30 miles, 5 miles out of Moscow. But at the end of the day, they paid the price. When it comes to Germany or South Korea, you don't have a buffer zone. I'm talking about Germany in the Cold War, of course. Germany in the Cold War didn't have a buffer zone. So when you are talking about imminent threat vis-à-vis Germany, it's not equivalent to an imminent threat vis-à-vis Russia, because it's contextually based. Geography does matter. Israel, for example, which is a generic example of the fact that preventive war is not allowed, but preemption when it comes to imminent threat is allowed, and I'm referring, of course, to the Six-Day War. Six-Day War is a generic example of that when it comes to an imminent threat, and in the 1967, we don't have time to elaborate, but there was an imminent threat upon Israel. 15 miles north of here, there is a city called Netanya, a coastal city. It was shelled in the Six-Day War by conventional artillery because of the fact that Israel's width is about 11 miles. I'm talking about Israel borders before Six-Day War, the Green Line. So the world has recognized that a preemption strike when it comes to defense of very small, heavy populated states, which has borders full of civilians along the borders, it's totally different from the case which I've just mentioned of Russia, for example. How does it relate to tunnels? I can give you a new example. A year ago, exactly a year ago, Israel has discovered 6 Hezbollah tunnels in its northern borders, in the upper Galilee. Hezbollah is a proxy of Iran. It wants to demolish the state of Israel. It says, every few months you hear a lecture from Hezbollah's leaders saying precisely we want to demolish the state of Israel. They have capabilities, hundreds of thousands of missiles. And now they added 6 tunnels. They have a special commando forces called Radzyner forces. Israeli settlements, civilians are living along the northern border, close to the Lebanon's borders. So we have 3 substantial risks. Heavy populated area, 6 tunnels which were just discovered, and strong commando forces called Radzyner of Hezbollah, which is aimed at attacking the northern settlements of Israel. Nevertheless, Israel was not allowed by international law to defend itself by military force. What Israel did was very smart, very sophisticated. It just flooded the tunnels with concrete. So in international papers, you can recognize the fact that the flood of the cement, of the concrete, is going through the other side of the border through Lebanon's villages. So everyone discovered where the tunnel starts from. But when it comes to prevention, Israel was not allowed to start a war because of its preventive attributes. But if there is a 4th criteria, and it was not there, but if, just for the sake of the hypothesis, if there was an imminent threat in terms of hard intelligence that an attack is coming, the fact that Israeli civilians are living close to the borders and are being threatened, the tunnels, the capabilities, and the intelligence that says that the attack is imminent might allow a preemption war. So first, and very important issue related to the discovery of tunnels is the issue of imminence. If there is an imminent threat, and I've just mentioned one factor, the geographical factor, it might justify a self-defense war. Another attributes which I would like to talk about, 3 minutes allowed me 5. Okay. That's the Israeli way of doing business. Otherwise, I shall dig a tunnel. Be careful. I shall bypass you.
6 is my last prize.
Okay. So, another issue which is very relevant to our discussion is the issue of the second criteria, of the first criteria. What does it mean an armed attack? If the mere digging of tunnels is not an armed attack, does armed attack has a threshold? Does it have a threshold? Or the mere use of force amounts to an armed attack? That's a very disputed issue. The International Court of Justice have said in the Nicaragua and the oil platform case, in a few cases, it's mentioned and repeated its statement that there is a requirement for significant scale attacks. And it excludes precisely frontier incidents. frontier incidents are not considered by the International Court of Justice to be an armed attack. The US was coherent and consistent in its rejection of this approach. And I can tell you a secret. When it comes to this approach, most states, and I follow Cassase and Dinstein, who write about the hypocrisy of the international community, and the best example is the issue of frontier incidents. According to the International Court of Justice, when you respond in a frontier incident, it's a reprisal. It's unlawful. That's the common view. Open any book in international law, and you will see, and there are statements by the International Court of Justice saying that if there is not a significant scale attack, you don't have the right to self-defense yourself. The Americans, the US approach, as I told you, is very precise against it. The English approach is quite similar to the American one. But in practice, all permanent members of the UN and most states adhere to the practice of reprisals. Namely, let's take a scenario. Let's assume, and this is a real example from the Israeli reality, that a tunnel was used for kidnapping, for abduction of a soldier. This is a frontier incident. According to the International Court of Justice, it doesn't justify a military response. In practice, and the International Court of Justice says it's an unlawful reprisal. In practice, most states do react, do respond. And the American approach, I think, is absolutely right in the sense that what the US says, the legal statement of the American is that we shall have to follow customary law, namely, we have to respond subject to the necessity and proportionality of our military response. And if it's a necessary response from a military strategy or from military perspective, and if the response is proportional, then it's lawful. And so, let's come back to the scenario. Let's assume that there is a kidnapping and abduction of a soldier. In Israel, it happened already, in Gaza. According to the American approach, you might respond by military force, as long as it's proportional and necessary. You might think, as a matter of intuition, but I think it's a strong intuition, think of it from a tet-for-tet perspective, which in terms of deterrence is a very effective strategy. So what most states, I would say, would respond or would react is to follow the American way. And many commentators say that the US is right, namely to justify reprisal when a tunnel is used for frontier incidents. You don't have to be a sitting duck when a frontier incident happens. And on-the-spot reaction, according to many states, and I think that's a right approach, should be lawful. As I told you, the International Court of Justice have ruled against it. So just to conclude, when it comes to tunnels, nothing is new under the sun. We have to adjust the international law. When it comes to the mere digging of tunnels, there is no right of self-defense. When it comes to the actual use of tunnels, you have either the right of self-defense if the threat is imminent, or in the case of a frontier incident, and it is disputed, you might respond on the spot as long as it's proportional and necessary. Thank you.